All rise, we will pray.
Good afternoon. Can everybody hear me? Good afternoon.
Good afternoon, I'm here.
We resume.
Good afternoon, Judge.
Hearing.
We can see and hear you clearly.
Very well, thank you. The appeal chamber will now continue hearing Mr. Mladić's appeal. Ratko Mladić, you have 1 hour for this participation as well.
We're waiting for the transcription of the. I'm not sure how much time we have left, but I'll continue with the arguments. As I was saying, the second error in this respect was that the trial judgment performs an analysis of what others, such as politicians, the police, or other armed groups said or did in the same time period prior to Mr. Mladić coming to Bosnia-Herzegovina. Much of this, and many of the crimes underpinning the overarching JCE, come in this time period before Mr. Mladić was in Bosnia and before the VRS. This violates the above jurisprudence as the trial chamber utilizes events that predates Mr. Mladić's appointment and geographic position to establish his mens rea and contribution to a JCE where the actus reus was before his physical and temporal presence. This is very much in error. Further, as to the temporal and geographic scope of the trial judgment, it did not take into account that the VRS started off with just Mladić and a few officers at the main staff, and that it took time to bring various remnants of the JNA, various local defense units, and even regional or local armed forces under the VRS's structure and command. By way of example, in Foča, it was several months before this took place. The judgment's analysis as to overarching JCE relies heavily on adjudicated facts, and you've heard my colleagues' submissions as to same. Crimes that took place before Mladić and his VRS had hierarchy and military command and control in all regions of Bosnia cannot be used to establish his mens rea, even if the actus reus is shown to be perpetrated by others. Now I will move on to the mens rea and actus reus being scrambled and muddled together in the analysis. The trial chamber erred in almost exclusively basing its analysis of Mr. Mladić's purported contribution to the overarching JCE on circumstantial evidence. In using this modus, these conclusions had to be the only reasonable inferences available. I would point to the appeal judgments in Lukic, paragraph 149, and Boškovski-Tarkulovski, paragraph 99, for this holding. As we see from the appeal, this was not the case, and the trial chamber thus committed discernible error in finding Mr. Mladić guilty. If I can direct your attention to paragraph 311 of our appeal, we have summarized that there was direct evidence that Mr. Mladić did not share a criminal intent in accord with the overarching JCE, which was not accepted by the trial chamber because it felt it had more circumstantial evidence to the contrary. This disregard of direct evidence in favor of circumstantial evidence is discernible error. It violates the above jurisprudence and violates in dubio pro reo. If the chamber has conceded that direct evidence exists showing a lack of criminal intent or mens rea as to Mr. Mladić, and if indeed that direct evidence is corroborated by other circumstantial evidence, as is shown in Appeal Paragraph 3112, footnote 463, then no reasonable trier of fact can choose to ignore that direct evidence and go with, quote-unquote, more circumstantial evidence to say that the, quote-unquote, only available inference is one indicative of guilt. Circumstantial evidence cannot outweigh direct evidence. Much of the direct evidence that was available to the trial chamber and which was disregarded included the notebooks that the chamber asserted as being authored by Mr. Mladić himself. Appeal paragraphs 202, 234, and 309 give some examples. The appellant submits that the trial chamber erred in law by employing a defective method that resulted in a finding of the appellant's mens rea being satisfied beyond reasonable doubt. Based on this fundamental legal error in the method of the trial chamber's analysis, the appellant invites the appeals chamber to overturn the trial chamber's convictions on the JC1 mode of liability pursuant to the Vasiljevich Appeals Judgment, paragraph 12, and Blashkich Appeals Judgment, paragraph 13. The first error was that the trial chamber made findings of the appellant's mens rea before the actus reus was established. This is akin to building a house before setting the foundation upon which it will stand. As explained in the appeal brief at paragraphs 271 to 285, to establish the actus reus element of JCE, the trial chamber must determine the existence and scope of a common criminal purpose shared by a plurality of persons. This is a necessary prerequisite in determining whether the acts performed by the appellant were related, contributed to the participation of the common criminal objective. Thus said the Stanisic and Samatovich appeals judgment in paragraph 82. We recall that the doctrine of JCE demands that the appellant made a significant contribution to the crimes for which he has been convicted. Here, both the Kreisnig appeals judgment, paragraph 215, and Burgenin appeal judgment, paragraph 987, set that forth, as does our appeal in footnote 273. This requires the trier of fact to characterize Mr. Mladić's contribution to the common criminal purpose. This is from paragraph 430 of the Burgeonin appeal judgment. Here, we must point out that the trial chamber and the prosecution in its response brief make assumptions and draw inferences that of Mr. Mladić to circumstantially link him to crimes based on his position in the VRS and the evidence of behavior of alleged subordinates to satisfy the guilt of Mr. Mladić by this mode. See judgment paragraph 3561, 4218 to 4239. Indeed, the prosecution has misled you by submitting that the word link, quote unquote, between Mr. Mladić in the overarching JCE with other participants is merely any link. Look to their response brief, paragraph 101. Thereby, the prosecution have confused the actual requirement from the Burgeonin appeal judgment, which requires an understanding or agreement to be that link. And that's paragraph 419. No other link works. The trial chamber also relied on circumstantial links.
Mr. Mladić, I'm advised that we have lost the connection with the presiding judge. Could you kindly pause until we re-establish connection? Thank you.
Of course.
Madam Presiding Judge, I'm advised that we have reconnected. Could you reconfirm that, please?
Thank you very much. The session is resumed. Mr. Lukic, please proceed.
As I was saying, the trial chamber also relied on circumstantial quote-unquote links rather than finding actual understanding or agreement by Mr. Mladić to support any overarching JCE. Quoting again to Judge Tuzmukhmadov's Sayinovich dissent at paragraph 34, no one incurs criminal liability merely by virtue of being a person of authority or capable of issuing instructions. Responsibility justifying a criminal conviction may attach only to individuals who actually put their powers into use for the commission of crimes or fail to exert their influence over perpetrators. And this must be proven beyond reasonable doubt. Once the actus reus is established, the trial chamber is then required to examine whether the appellant's shared intent to further the common criminal objective could be inferred from his knowledge, acts, words, and interactions with others. Stanisic and Samatovich appeals judgment. Paragraph 82. Again, much like a person building the foundational layer upon which their house will be built, the trial chamber is required to determine the objective actus reus elements of JCE first, before the subjective mens rea element can be considered. And that's from the same appeals judgment, Stanisic, Samatovich, paragraph 82. The appellant submits.
Mr. Ivitich, I apologize. We have lost connection with one of the judges, so we'll try to reestablish connection. Thank you. Madam Presiding Judge, can you see and hear us clearly now? And so Judge Ngam as well?
I can. Shall we proceed?
Thank you, Your Honor. The appellant submits that the second error in the trial chamber's analysis was when it made mens rea findings while doing the actus reus consideration. That's in the appeal at paragraphs 262 to 290. The consequence of this is that if mens rea inferences are drawn prior to the actus reus being established, not only does this contravene the established method explained in the first error, but how can the trial chamber then, moving into the mens rea consideration, remain objective when they have already made findings about and against the appellant's mental state? Reliance on conclusions already drawn about the appellant's guilt does not provide an objective or balanced analysis of the appellant's mens rea. Instead, the trial chamber automatically applies these findings to conclude Mr. Mladić's guilt, thereby indelibly tainting their findings. You could see this in our appeal, paragraph 291, and our reply, paragraph 55. On this very point, the prosecution was unable to address this error, but rather chose to paint over the elements with a broad brush. The appellant avers that the method used by the trial chamber to establish the different elements of the OJCE are flawed. This invalidates the trial chamber's findings for the OJCE. Such a piecemeal approach deprived the appellant of his rights under in dubio pro reo, fair trial, and the jurisprudence which we have discussed earlier. In essence, the trial chamber has not been able to articulate by what measure Mr. Mladić was involved in crimes or furthered the common criminal purpose. In light of these facts, we submit that the judgment failed to properly characterize through which specific conduct Mr. Mladić contributed to the overarching JCE, again, during the relevant time period he was in Bosnia-Herzegovina and in the VRS. By using such a nebulous and blurred analysis, muddling the actus reus analysis and the mens rea analysis, the trial chamber ultimately left open whether it held Mr. Mladić responsible for active conduct, omission, or both. Now I'd like to talk about the civilian police, MOOP, and paramilitaries. The trial chamber identified approximately 60 paramilitary groups on the territory of the Bosnian Serb Republic, totaling between 4,000 and 5,000 men as of July 1992. And it conceded Mr. Mladić's efforts to disarm and disband those units and groups. See in the judgment, paragraph 3855. No reasonable trier of fact would ignore constant attempts of Mr. Mladić and his VRS to eradicate paramilitaries, while including acts that were alleged to be committed by these same paramilitaries who were named as participants in the overarching JCE. To be blunt, Mr. Mladić cannot have been fighting to eradicate Serbian paramilitaries while at the same time contributing to their actions and thus significantly contributing to the alleged common objective through these paramilitaries. In doing so, the trial chamber failed to give sufficient weight to General Mladić's many orders to subordinates to break up, disarm, and liquidate Serbian paramilitary groups, and arresting them if they had committed crimes. The appellant's approach to not tolerate any actions or existence of paramilitary groups is supported by various meetings evidenced in the notebooks attributed to him. See, for example, in our appeal, footnote 452. Indeed, the consistent opposition of General Mladić to the existence and activities of paramilitary groups is evidenced and documented from the entire period from when he came to Bosnia in 1992 through the end of the alleged overarching JCE in 1995. Please look to appeal, paragraph 310. The selective, erroneous, and biased approach of the trial chamber was followed by a superficial approach on evidentiary assessment as to findings on paramilitary structures. Instead of reaching conclusions in favor of the appellant under the direct evidence of his opposition to paramilitaries, the trial chamber attempted to somehow portray non-existing connections and the impression of joint furtherance of common objectives with the VRS through ambiguous terminology based on circumstantial evidence and unacceptable for proper Article 7.3 analysis, using words like operated in cooperation, cited several times in the judgment. Look at 3859 and 3866, for instance. Worked in coordination, judgment 3863, pardon me. Worked in cooperation with VRS units, judgment paragraph 3873. But again, direct evidence shows otherwise. One example, an elite VRS unit directly subordinated under General Mladić, the 65th Protection Regiment, was personally sent by General Mladić to Ilija and engaged to deal with a paramilitary group. Here we have Radojcic, transcript page 23055, and wherein he continued, that group outnumbered the military police available to that brigade commander, who asked for Mr. Mladić's help to deal with this group. Orders were issued to disarm and arrest them. An example is P5112. Only those who had not committed crimes were allowed to submit to the rules of war and submit to Army induction, and they were separated, assigned to different units so as not to work together. Unrefuted evidence defies to meet the requisite legal elements as to JC1 liability. The VRS and Mr. Mladić's position as to paramilitaries is, quote, that the patriotic motives of the above-mentioned individuals are secondary, and unlawful enrichment and looting is the only reason for their presence in this area, end quote. Moving on now to the civilian police known as the MUP, the trial chamber's flawed approach is most evident in its use of adjudicated facts and flawed logic to establish that Mr. Mladić had command and control over the MUP, even though, at most, all he did was order the VRS Army to cooperate in legitimate actions with the MUP. Look at appeal paragraph 218 to 221 and contrast with the trial judgment paragraph 3794. This error is best illustrated in the judgment where the trial chamber concedes it cannot identify between actions and crimes committed by the VRS or members of the MUP and others, but rather stirs them all together in the same cauldron for purposes of the overarching JCE. And I'll quote that paragraph to you. Quote, many of the charged crimes were committed by members of the VRS who were under the operational command of one of the corps and ultimately of the VRS main staff. Many other crimes were committed by the MUP members, either under the operational supervision of the VRS or under the supervision of the MUP. Some crimes were committed by the territorial defense members under the supervision of the Bosnian Serb Ministry of Defense. Crimes were also committed by paramilitary groups subordinated to the VRS or MUP, end quote. The trial chamber resorted to inventing a brand new mode of liability in command and control jurisprudence, quote unquote, operational supervision. What is it? Upon what basis in law and jurisprudence does it arise? The trial chamber is silent on this point. Evidence to the contrary is not silent and should have led the trial chamber to abandon its creative folly. First of all, evidence was submitted to rebut the adjudicated fact as to command and control. Look at our appeal, paragraph 218. Secondly, the record is replete with reliable and credible evidence that coordinated action of the MUP with the VRS did not lead to resubordination under the Army's command. Here, look at appeal paragraph 221, which includes the prosecution's own expert, Renown Tonins, at transcript page 20615 to 20617. The evidence showed that at all times, the effective control, reporting, and discipline of MUP units remained with the MUP commander and MUP ministry. Appeal, paragraph 221, footnote 327. Based on this evidence as to the MUP, and in accord with the requirements of indubio pro reo, it was unreasonable and therefore an error for the trial chamber to find the appellant shared the intent of the MUP or that he contributed towards the common criminal purpose of any overarching JCE via the actions of the MUP. Now I'd like to switch gears to talk about legitimate goals of the Army. Respectfully, the trial chamber further erred in its conclusions linking Mr. Mladić's legitimate activities to political goals of politicians. The trial chamber found that Mr. Mladić could influence the political leadership. That's discussed in the judgment at 4474, appeal paragraph 204. But at the same time, it refers to evidence that Mr. Mladić was continually subject to the political leadership. Judgment paragraphs 4466 and 4472 through 4474. Indeed, the trial chamber chose selectively the statements of UN outsiders in interpreting the behavior of Mr. Mladić that were often contradictory to one another. We've set that out in the appeal at paragraph 204. For example, contrary to reliance on witness Wilson in the judgment, paragraph 4473, and its use and oversimplification elsewhere in the judgment as to the existence of a supreme command for all tasks and objectives of the armed struggle, it should be noted that the same document used throughout the judgment, P338, at page 159, plainly set forth that General Mladić's VRS main staff was formulating its own military tasks, i.e. 7 overall military goals, instead of 6 strategic objectives as formulated by politicians. There was no malicious meaning attached to them. They simply provided for formulating legitimate military tasks. It should be recalled that this was all at a time when it was clear that the Bosnian Muslims and Bosnian Croats had already established their own armed forces, and attacks by these forces had been directed against municipalities in Bosnia and Herzegovina. The judgment, besides speculative narratives, does not contain conclusions nor important analysis as to whether even the political strategic objectives nor the AB variant document were criminal per se. Hence, conclusions previously reached in the Perisic appeals judgment should direct us, namely that, quote, the implementation of the RS strategic objectives did not entail the systematic commission of crimes, end quote. That's to be found in paragraphs 100 to 102 of the Perisic appeals judgment and must be taken into consideration. It's also identified in paragraph 243 of our appeal. Merely citing and speculating on objectives of a political nature do not satisfy the standard of evidence sufficient to establish the existence of a common criminal plan. We recall here the holding from the Mladić Appeals Chamber that political intentions are not sufficient to establish a joint criminal enterprise, and that's at paragraphs 123 to 124. The absence of any correlation or identical agenda between Mr. Mladić and the VRS on the one side and political authorities on the other, let alone a common criminal objective, is seen in paragraph 3707 of the judgment. But instead of analyzing the clear divergency between political and military goals, the judgment lacks proper analysis and application of in dubio pro reo. Per the arguments in paragraph 206 of the appeal, considering the undue weight given to evidence of the appellant's role in establishing the VRS, in light of the existing jurisprudence that, quote, one's routine duties will not exculpate them, end quote, we submit this standard is interpreted and turned upside down. Performing routine duties in isolation is insufficient to establish indication of guilt and cannot substitute the requisite actus reus or mens rea as to any overarching JCE. The trial chamber failed to explain how performance of routine military duties of Mr. Mladić had an actual effect on and substantially contributed to the activities of perpetrators in the course of crimes in furtherance of the common objective. Without such analysis, the trial chamber has not been able to articulate by what measure Mr. Mladić was involved in crimes committed in furtherance of the alleged common objective. There is a clear error in reasoning that Mr. Mladić has made a significant contribution to the OJCE. It should be recalled in this regard that the VRS in the Perisic appeals judgment was confirmed to be an organization that was not criminal in itself and which undertook lawful combat activities. That's in paragraphs, that's in our appeal paragraph 206. Even a highly controversial doctrine of JCE demands that the appellant made a significant contribution to crimes, which requires the accused's contribution to the common objective. Burgeon Appeal Judgment, paragraph 430. How acts and conduct of Mr. Mladić performing his routine duties as a military commander had any tangible effect on crimes which were committed in furtherance of a common objective remain completely unanswered. We reiterate that this is an error, as in paragraph 235 of our appeal. The trial chamber ignored the reasonable inference of Mr. Mladić's comments and speech at the 16th Bosnian Serb Assembly when he first assumed the title, his title in the VRS, wherein he stated, quote, "We do not want a war against the Muslims as a people or against the Croats as a people," end quote. Appeal, paragraph 325. This is said after Karadzic proclaimed the 6 strategic objectives, and its plain interpretation is to only engage in war when attacked and against combatants, not civilians, which is a legitimate stance. Appeal, paragraph 326. By failing to consider the same, the trial chamber erred as to in dubio pro reo. Orders from the VR's main staff in evidence, particularly those from Mr. Mladić, were entirely lawful and legitimate. They were specific to the extent that can be interpreted as of a military nature. Their purpose cannot in any way be connected to any criminal plan or objective whatsoever. Starting with directive number 1, upon assuming command of the VRS, General Mladić consistently urged adherence to the Geneva Conventions and proper treatment of civilians and POWs. Appeal paragraph 311 to 312. These orders indicate that the appellant ordered his subordinates to abide by international law and did not order them to further the objectives of any common criminal objective. We believe that given the trial chamber's complete disregard of this direct evidence of lawful orders from Mr. Mladić, it is incumbent upon this appeals chamber to intervene in the trial chamber's mens rea analysis, where this direct evidence of probative value has not been given sufficient weight. For those reasons, we would ask that you vacate the trial chamber convictions based on an overarching JCE and grant ground 3 of the appeal, and I yield the floor to my colleague as to ground 4.
Madam Presiding Judge, Your Honours, I will now be addressing the Chamber on ground 4. I will not be addressing the Chamber on every subground within ground 4, which relates to the trial chamber's errors in relation to Sarajevo. My submissions will be focused on ground 4A1, that the trial chamber erred in law by finding that the tribunal has jurisdiction over the crime of terror. The appellant submits the trial chamber's error invalidates the conviction entered on count 9 for the crime of terror. The appellant's written arguments are at paragraphs 336 to 349 of the appeal brief and paragraphs 67 to 69 of the reply. Before turning to my submissions, it's important to note that our argument is focused on the fact that the criminalisation of terror could not be considered to have formed part of customary international law during the indictment period. The appellant does not challenge the finding that there existed a custom on the prohibition against terror, paragraph 341 of the appeal brief. I will start by considering the legal basis relied on by the trial chamber to conclude it did, in fact, have jurisdiction over the crime of terror. At paragraph 3185 of the judgment, the trial chamber held that, quote, "The appeals chamber has confirmed that the tribunal has jurisdiction over this crime," close quote, and cited 2 cases in support of this conclusion. the Garlic appeals judgment, and the Dragomir Milosevic appeals judgment. These will be taken in turn. The Garlic Appeals Chamber, in the first instance, acknowledged the Secretary General's remarks that, quote, the International Tribunal was expected to apply rules of international humanitarian law which are, beyond any doubt, part of customary international law, end quote, paragraph 81. It then went on to explain the importance of forensically analysing the jurisprudence to avoid confusing a custom prohibiting certain conduct with a custom that criminalises it. This was because, quote, in most cases, treaty provisions will only provide for the prohibition of certain conduct, not for its criminalisation, or the treaty provision itself will not sufficiently define the elements of the prohibition they criminalise, end quote, paragraph 83. After considering domestic practice to determine whether or not there was sufficient state practice to evidence a norm of customary international law for the criminalisation of terror, the Appeals Chamber found that individual criminal responsibility could be inferred from state practice. Paragraph 92. Judge Schomburg dissented. It pointed to 6 states to evidence state practice: the Ivory Coast, Czechoslovakia, Ethiopia, the Netherlands, Norway, and Switzerland. The other states it pointed to, Ireland, Bangladesh, the United States, China, and the former Yugoslavia, on closer inspection, did not, in fact, criminalise terror, so cannot be said to constitute evidence of state practice in this regard. I would refer the Chamber to Judge Schomburg's dissent at paragraphs 9 to 13, and also the appellant's reply at paragraph 68. Therefore, on the basis of 6, or at best 12, states, the Garlic Appeals Chamber concluded, beyond any doubt, a breach of the prohibition against terror in a manner corresponding to the additional protocols in the Geneva Convention gave rise to individual criminal responsibility under customary international law. Paragraph 96. The Appeals Chamber in Milosevic did not take this issue much further. It relied on the Garlic Appeals judgment to conclude that the tribunal had jurisdiction over the crime of terror because its criminalisation was part of customary international law. Paragraph 30. Judge Liu dissented in Milosevic. He alone chose to undertake an independent analysis of the jurisprudence. He endorsed Judge Schomburg's dissenting analysis in Garlic and concluded a custom criminalising terror could not be established due to the absence of sufficient state practice. It's important to consider the Garlic Appeals Chamber's approach to state practice in light of the North Sea Continental Shelf case. In this case, the International Court of Justice found that state practice could only evidence a custom where it was, quote, both extensive and virtually uniform, end quote, paragraph 74. Where state practice is inconclusive, a custom cannot be established. Of the 6 states the Garlic Appeals Chamber pointed to that did actually criminalise terror. There is not a single state from the Permanent Five of the Security Council at the time, not a single one located in Asia, the Americas, or Oceania. There are no common law or other legal systems represented. The state practice it purported to find from these 6 states is insufficient evidence of settled practice, extensive practice, or virtually uniform practice as required by the North Sea Continental Shelf case. It falls demonstrably short of what was required to show beyond any doubt that the criminalisation of terror was part of customary international law at the material time. The 4th TADX jurisdiction condition reads, quote, "The violation of the rule must entail, under customary or conventional law, the individual criminal responsibility of the person breaching the rule." Close quote, paragraph 94. The appellant submits that the Garlic Appeals Chamber failed to establish such a custom. As a result, there are cogent reasons to depart from this decision. I will now consider the impact the trial chamber's deference to this decision had on Mr. Mladić. As demonstrated by paragraph 3185 of the judgment, the trial chamber relied on and recycled the erroneous legal basis proffered by the Garlic Appeals Chamber for the criminalisation of terror. It did so without conducting any form of legal due diligence itself. The error in Garlic was pointed out by the defence at trial, but the trial chamber failed to engage with the issue and concluded that there was, quote, "nothing which would lead it to deviate from the established case law," close quote, paragraph 3185. Had the trial chamber conducted any form of legal analysis, it could not have satisfied itself beyond any doubt that the criminalisation of terror was part of customary international law during Mr. Mladić's indictment period. The Secretary-General made it clear that the principle of nullum crimen sine lege required the tribunal to apply rules that were beyond any doubt part of customary law at the time of the relevant offence. The criminalisation of terror does not meet this threshold. For this reason, the appellant submits that the trial chamber fell into error when it relied on the Garlic Appeals Chamber's findings that it could exercise jurisdiction over the crime of terror under Article 3 of the statute. For this reason, the appellant invites the chamber to overturn Mr. Mladić's conviction on count 9 and remove considerations of the crime from the analysis of the alleged Sarajevo JCE. I will now defer.
May I interrupt you, Ms. Bagat?
Yes, of course.
I think this will be an appropriate time to take an hour's break. Therefore, the proceedings are paused until 1 hour from now. All rise.
All rise, we will leave.